Welcome to the Deep Dive. We're here today to unpack a stack of sources you've shared with us, digging into a really significant topic. Recent international legal findings concerning the Israeli occupation of Palestinian territory. Think of this deep dive as us trying to get a clear picture, of what some key international legal bodies have actually said about the situation. And we're basing this entirely on the articles, the research, the documents that you provided.
That's right. And our job here is to help you navigate these complex findings. We'll look at recent opinions from the International Court of Justice, actions by the International Criminal Court, related UN resolutions. Basically, what do they say about the legality of the occupation itself? What are other countries supposed to do or maybe not do? And those big issues like, taking territory, reparations for damage, getting humanitarian aid through.
And importantly, we're focusing strictly on the legal analysis presented in these sources you sent.
Exactly. We're looking at what the documents lay out, the specific conclusions drawn by these international bodies. It's about understanding the legal arguments and findings presented in these materials.
Okay, let's dive in then. Right at the forefront of the sources, there's this major legal development. The International Court of Justice, the ICJ, that's the UN's main court, basically it pronounced itself on the legality of the Israeli occupation back in July 2024. Now, the sources do mention this question, the legality question, and it come up before in different ways, legally, politically. But they really seem to emphasize that this specific advisory opinion brought it right into the political foreground, as they put it.
It felt like a watershed moment in some ways.
Yeah, like the highest international court weighing in very clearly.
That's right. And the sources, they trace the path to this ICJ opinion. It wasn't out of the blue. They point back to 2017, when the UN Special Rapporteur for Human Rights in the occupied Palestinian territory first recommended getting an ICJ opinion on this. Then that idea was reinforced in 2022 by a UN International Commission of Inquiry. They concluded there were strong grounds to believe the occupation might have become unlawful, specifically because it seemed so, permanent.
Right, not temporary like occupation law assumes.
Precisely. And shortly after that commission's report, the UN General Assembly formally requested the advisory opinion from the ICJ. And that's what led to the court's big pronouncement in July 2024.
So what was the absolute core finding from that July 2024 opinion as the sources present it? What did the court actually say?
The sources are really clear on this. The central finding, the main takeaway, is that Israel's presence in the occupied Palestinian territory, and the court specified this includes the West Bank, East Jerusalem, and the Gaza Strip, is unlawful under international law.
Unlawful. Okay, that's a powerful legal statement. How, based on the documents you shared, did the court arrive at that specific conclusion? What was the legal reasoning?
Well, the court applied some really fundamental principles of international law. The sources highlight that it relied heavily on what are known as peremptory norms. You might also hear the Latin term jus cogens.
Jus cogens.
Okay. Think of jus cogens as the sort of super norms, the basic non-negotiable rules of international law. Rules so fundamental that no country can just decide not to follow them or make a treaty that violates them.
Got it. Like bedrock principles.
Exactly. And the sources point to some key jus cogens norms the court applied here.
Yeah.
Things like the prohibition against taking territory by force, a huge one. The right of peoples to self-determination. So, the right of the Palestinian people to decide their own political future. And also, the binding rules found in international humanitarian law and human rights law. Now, what's particularly striking about this finding, and the sources really emphasize this, the court didn't just say specific actions during the occupation were illegal.
Right.
It found that the occupation itself, the whole situation, has become what's called an internationally wrongful act. Why? Because of how incredibly long it's lasted, and because of what the sources describe as Israel's acquisitive policies.
Acquisitive policies, meaning aimed at keeping the territory.
Essentially, yes.
Yeah.
Policies aimed at gaining permanent control over the territory. And the court concluded, according to the sources, that this situation is so fundamentally wrong under international law that it has to end, unconditionally and rapidly.
So just to be clear, it's not only about, say, whether building a settlement violates the rules within an occupation, but the very fact that the occupation continues under these specific conditions, the length, the policies, that's the core legal violation the court identified.
Precisely. According to the sources, that's the ICJ's reasoning. This prolonged presence, combined with these acquisitive policies, fundamentally changes the legal picture. It makes the presence itself unlawful and demands an immediate withdrawal. And the sources note another really significant point from the opinion. The court definitively rejected Israel's long-held argument that the Fourth Geneva Convention doesn't fully apply to the occupied territory.
Ah, that's been a point of contention for decades.
A
But
major one. But the court reiterated its stance from a 2004 opinion it gave on the wall. It said the Fourth Geneva Convention applies in full, period. The sources suggest this is a huge legal clarification because that argument about the convention's applicability had persisted for so long without such an authoritative pushback from the ICJ.
getting that clarity on the Fourth Geneva Convention's full applicability is definitely significant. You mentioned Cogent's rules being fundamental. The sources also mention another term, erga omnes. What does that mean for other countries? What are the consequences of this unlawful finding for states beyond Israel?
Right, erga omnes. Another bit of Latin, it means towards all, or owed to everyone. The court found that the rights and obligations involved here, like self-determination, prohibiting force to take territory, these Cogent's rules, they also have this erga omnes character. What that means, essentially, is that these are obligations a state owes not just to one specific country it might have a dispute with, but to the entire international community. Everyone has an interest in upholding them.
Okay, so it's a collective responsibility.
In a sense, yes. Because these key rules have this erga omnes character, the sources explain the ICJ concluded that all other states, every country, basically are now under specific legal obligations. Two main ones. First, they must not recognize the situation created by Israel's unlawful presence as being legal. No stamping it with legitimacy.
So no saying, oh, this is fine now.
Exactly. And second, they must not provide any aid or assistance that helps maintain that unlawful situation. The sources really highlight that the court sees the whole international community as having a stake in making sure these fundamental rules are respected.
Okay, so the ICJ delivers this major opinion in July 2024, declares the occupation unlawful, spells out these obligations for other countries. What happens next in the international system? What do the sources say followed this ruling?
Well, the sources tell us the ICJ itself didn't dictate exactly how to end the unlawful presence. It said the specifics, the modalities, were really a matter for the UN General Assembly and the Security Council. They are the ones who asked for the opinion after all. So following that guidance, in September 2024, the UN General Assembly stepped up. It adopted a resolution. The sources identify it as Resolution ES 2024, and this resolution was specifically designed to give effect to the ICJ's advisory opinion.
And what did that General Assembly resolution actually demand? What actions did it call for?
According to the sources, it was quite direct. It demanded that Israel end its unlawful presence and fully withdraw from the occupied Palestinian territory by a specific deadline, September 2025.
A deadline. Wow, did it stop there?
No, it went further. The resolution also called for comprehensive reparations to be provided. That includes things like compensation for all the damage caused, but also the return of Palestinians who were displaced. And, importantly, a call on countries to adopt lawful countermeasures against any entities, companies, organizations, whatever, that are supporting the continuation and entrenchment of Israel's occupation.
Okay, so you have the UN's highest court making a finding, and then the main representative body, the General Assembly, issuing these demands with a deadline. Did Israel comply? What was the response?
Well, the sources are pretty blunt here. They state that, quote, as expected, Israel has not complied with the court's findings. They note Israel responded by, quote, doubling down on previous arguments, basically rejecting the court's conclusions.
Not entirely surprising, perhaps, given the history.
Right. It may be more concerning from the perspective of actually enforcing international law. The sources also point out that very few third states have taken concerted action to uphold their own legally defined obligations, those obligations of non-recognition and no assistance we just talked about. They even include a quote from Judge Dyer Talati, who was one of the judges on the ICJ panel for this opinion. He expressed his concern that the opinion might end up being, quote, meaningless if the United Nations does not act upon the advice provided by the court.
That's a stark warning from one of the judges. It really highlights the gap between a legal ruling and, real-world change.
Absolutely.
This raises a really important question, and one the sources seem to dig into. If countries are obligated not to recognize the unlawful situation or help maintain it, what more are they supposed to do? Especially when the state found to be violating the law, like Israel here, isn't complying. Are there further obligations?
Yes, the sources explore this exact point. They point to several existing international legal frameworks. These aren't new laws created by the ICJ opinion, but existing ones. The opinion clarifies the application of that create responsibilities for the whole international community to actively try and bring the occupation to an end. The sources specifically mentioned three key legal bases: Common Article 1, which is found in all four Geneva Conventions of 1949. Then there are the articles on the responsibility of states for internationally wrongful acts, often just called ORSWA, and also Article 25 of the UN Charter, which deals with obeying Security Council decisions, though that's slightly different context.
Let's focus on Common Article 1 of the Geneva Conventions for a moment. It says countries undertake to respect and to ensure respect for the present convention in all circumstances. That sounds important. What does that phrase, ensure respect, actually mean in practice for other countries looking at this situation?
That's the crucial part. The sources explain that respect is the straightforward bit. It means you, as a country that signed the treaty, have to follow the rules yourself. Standard treaty law, pacta sunt servanda, as they say, but ensure respect. That's the more active obligation. The sources cite interpretations from the ICJ itself and also extensive commentary from the International Committee of the Red Cross, the ICRC, who are sort of the guardians of the Geneva Conventions. These interpretations, backed up by state practice and legal rulings over time, clarify that ensure respect means all countries who signed the Geneva Conventions have an obligation to take steps to make sure other signatory countries are also following the rules, even if they aren't directly involved in the conflict themselves.
So it's not just about minding your own business. You have a positive duty regarding others.
Exactly. The sources explain it has two aspects. An internal one, making sure your own forces, your own people, comply. But also this really important external aspect. It means taking measures to ensure compliance by others, like Israel as the occupying power in this instance. And the sources note the ICJ in its 2024 opinion was explicit about this. All countries party to the Fourth Geneva Convention have a duty to ensure Israel complies with the humanitarian laws in that convention concerning the occupied territory. It's presented as a firm legal obligation, not just a political suggestion.
An active duty, then, to try and make sure the rules are followed, not just hoping they are.
Precisely. The ICRC commentary, as cited in the sources, really emphasizes this. By signing, countries committed to taking all reasonable measures to prevent violations from even happening. And if violations do occur, the commentary says countries only fulfill their legal duty if they've done everything reasonably in their power to bring the violations to an end. And the sources stress this duty applies in all circumstances and covers all violations, although there's naturally a stronger expectation to act when dealing with serious ones.
Okay, so what kind of reasonable measures or steps are countries actually expected to take, especially when the violations are considered serious? What do the sources or the commentaries they cite suggest?
The sources, drawing from that ICRC commentary and also citing things like EU guidelines, provide a whole spectrum of possible measures.
Yeah.
They start, with diplomatic actions, quiet démarche, public condemnations, raising the issue in international forums. They can involve referring the situation to international organizations, the UN Security Council, the General Assembly, maybe even back to the ICJ for contentious proceedings if possible.
So diplomatic and institutional pressure.
Right. Then the sources mention measures of retortion. These are actions that are technically legal but definitely unfriendly. They signal strong disapproval. Think halting ongoing negotiations, refusing to renew special trade privileges, cutting back on voluntary aid unrelated to humanitarian needs. But then, more significantly, the sources discuss using lawful countermeasures. Now, these are actions that would normally be illegal under international law, like breaking a trade agreement, but become permissible when taken by one state specifically in response to another state's ongoing internationally wrongful act. The goal has to be to get the violating state to stop the wrongful act and comply with its obligations.
Okay, what kind of countermeasures are listed?
The examples given in the sources include things like arms embargoes, restricting specific trade or financial transactions, banning flights, or suspending aid and cooperation agreements that might, inadvertently benefit the occupying power's control over the territory. The sources also include supporting efforts to prosecute individuals suspected of committing serious violations or grave breaches, whether in national courts under universal jurisdiction or before international courts like the ICC.
That gives a much clearer picture of the toolbox, so to speak. And the sources emphasize these obligations are particularly strong for serious violations and grave breaches. Could you give some examples of those cited?
Sure. The sources list several acts that qualify as serious violations, triggering this heightened duty for other states. Things like willful killing, torture or inhuman treatment, widespread destruction or appropriation of property not justified by military necessity and carried out unlawfully and wantonly. Also, unlawful deportation or transfer of people, taking hostages, launching indiscriminate attacks affecting civilians, using prohibited weapons. And very relevant here, the transfer by the occupying power of parts of its own civilian population into the territory it occupies. That's explicitly mentioned.
The settlement issue,
Yeah.
directly.
Directly. They also include practices of racial separation and discrimination, which the ICJ also found relevant. And the sources stress a critical point from international law. Just because taking action might be politically difficult or inconvenient, that's not a valid legal reason for a state to avoid its duty to try and end serious violations. It's framed as a duty of due diligence. States have to make reasonable efforts to stay informed about what's happening, be open to information from various sources, including NGOs and UN bodies, and then act reasonably based on that information.
Okay, so the ICJ finding leads to a UN resolution with a deadline. Existing laws, like Common Article 1, clarify that other countries have an active role, with a range of measures available. Beyond stopping violations, the sources also mention reparations. The ICJ called for full reparation. What does that mean legally in this context?
Yes, the ICJ determined Israel has a legal obligation to provide full reparation for all the damage caused by its internationally wrongful acts stemming from the unlawful occupation and the specific violations within it. The sources bring in a really fundamental principle from the law on state responsibility. It goes way back to a famous 1928 case called Corzo Factory, and the ICJ reaffirmed it in its 2004 Wall opinion. The principle is basically that the state responsible for the wrongful act must, as far as possible, wipe out all the consequences of the illegal act and reestablish the situation which would have existed if that act had not been committed.
Wipe out the consequences,
Yeah.
trying to undo the harm.
Exactly. And the sources, drawing from international legal principles on state responsibility and the right to a remedy for victims, break down this full reparation into three main forms: restitution, compensation, and satisfaction, though satisfaction is less detailed in the provided outline.
Okay, let's take those one by one. What does restitution mean here, practically speaking?
Restitution is seen as the primary way to make things right. The goal, as the sources cite, is to reestablish the situation which existed before the wrongful act was committed. So, going back to the Wall opinion example, the sources say this meant returning specific lands, orchards, olive groves, businesses that were seized to build the wall. Applying that principle more broadly, based on the ICJ's recent findings about the unlawful occupation itself, restitution would logically mean ending the unlawful presence entirely, withdrawing forces, withdrawing the administrative control from the occupied territory, and crucially, dismantling all the settlements and the related infrastructure, roads, checkpoints, etc., built to support them. It's about trying to physically reverse the changes on the ground linked to the unlawful acts.
That sounds like a truly massive undertaking, aiming to literally return to the situation before. What about compensation? When does that come in?
Compensation comes in, the sources explain, mainly to cover damages that can be measured in economic terms, especially when restitution isn't physically possible, like you can't bring back a life lost, or when restitution alone isn't enough to cover the full harm. The sources emphasize it's not meant as a punishment. It's about addressing the actual losses suffered because of the wrongful act. And according to international principles, it should be proportional to the gravity of the violation and the harm caused.
What kinds of losses should compensation cover, according to the sources?
They list several categories, drawing on established principles. Material damages, obviously destroyed homes, damaged property, lost income, confiscated assets, but also lost opportunities, like being unable to work, get an education, access health care because of the occupation's policies. It also includes compensation for physical or mental harm suffered. And non-material harm, sometimes called moral damage, things like emotional distress, suffering, damage to reputation, violations of dignity. And finally, any costs incurred by the victims trying to deal with the situation, like legal fees or expert assistance costs.
That's quite comprehensive. Now, the sources also mention something called UNROD, the UN Register of Damage from the Wall. Is that part of this reparations framework? How does it fit in?
Yes, the sources do discuss UNROD. It was set up after the ICJ's 2004 Wall opinion, specifically, as the name suggests, to register or document claims for damage caused by the construction of the wall in the West Bank, looking ahead to future reparations. However, the sources raise some pretty significant questions about its current effectiveness. They point out that UNROD's mandate is limited. It only collects and documents claims. It doesn't have the power to actually verify the claims, evaluate the extent of the damage, or assess the monetary value of the loss.
So it's just a list, essentially.
Pretty much. And the sources argue that for reparations to be legally meaningful, to actually provide a remedy as required by international law and align with the ICJ's call for an international mechanism, UNRWRITE would need substantial reforms. It would need to become an active part of a claims processing system, one that could verify claims, assess damages, and ultimately lead to awarding compensation or facilitating restitution. Right now, the sources suggest, just listing claims without addressing the cessation of the wrongful act, restitution, or compensation doesn't really offer a proper remedy and falls short of what state responsibility law requires. It lacks remedial value, as they put it.
Okay, so a potential tool, but needing significant upgrades to be truly effective for reparations. Now, moving beyond the responsibility of states and reparations for damages, the sources also touch on holding individuals accountable for alleged crimes.
That's right. They bring the International Criminal Court, the ICC, into the picture, and they highlight a very significant development from November 2024. They note that the ICC prosecutor requested, and the pretrial chamber subsequently issued, arrest warrants for Israeli Prime Minister Netanyahu, former Minister of Defense Gallant, and also for Hamas leader Mohammed Diab Ibrahim al-Masri. These warrants are in connection with alleged war crimes and crimes against humanity committed since October 7, 2023.
Arrest warrants from the ICC. What does that mean legally for other countries?
The sources are very clear on this. For countries that are states parties to the Rome Statute, the treaty that established the ICC, these warrants trigger a general legal obligation to cooperate fully with the court. A key part of that cooperation is arresting and surrendering individuals named in warrants if they happen to be on that state's territory. And the sources strongly emphasize a specific point from the Rome Statute itself. A person's official position, whether they're a prime minister, a minister, a head of state, provides absolutely no immunity from criminal prosecution before the ICC. That principle of no immunity for official capacity is explicit in the treaty.
So status doesn't protect you at the ICC. Could the ICJ's findings from the July 2024 advisory opinion, the one about the occupation being unlawful, could those findings potentially influence the ICC prosecutor's work?
The sources suggest they could. Yes. While the ICJ deals with state responsibility and the ICC deals with individual criminal responsibility, the legal determinations made by the ICJ might inform the legal analysis of the ICC prosecutor. They specifically point to Israel's settlements policy and the related issue of unlawfully transferring populations. These were central to the ICJ's finding that the occupation is unlawful, and the sources note these are also issues the ICC prosecutor has been investigating as potential war crimes for some time. So the ICJ's legal conclusions could potentially bolster those lines of investigation at the ICC.
Interesting connection.
The sources also bring up another potential crime under the ICC's Rome Statute, the crime of aggression. They note that the definition of aggression in the statute includes any annexation by the use of force of the territory of another state or part thereof.
Annexation as aggression.
Yes. Now, actually prosecuting the crime of aggression at the ICC itself can be procedurally complicated. For situations like this one, it would likely require a referral from the UN Security Council, which can be politically difficult to obtain. However, the sources argue that even with those procedural hurdles at the ICC, individual states should still use the ICJ's legal findings, especially those regarding annexation, to potentially prosecute individuals responsible for aggression in their own national courts where possible, or to push for accountability through other means.
Okay. The sources really go into quite a bit of detail, as you said, about specific Israeli policies that the ICJ considered when it made its findings. Let's look more closely now at how that prohibition on annexation plays out in the court's analysis, based on the sources.
Right. The ICJ, according to the sources, defines annexation in this context, the context of military occupation, as essentially the occupying power forcibly taking over the territory it occupies, or integrating it into its own territory. The key element driving this, as described in the sources, is the clear intent by the occupying power to exercise permanent control over that land.
The sources mention the court noting a distinction sometimes made between de jure and de facto annexation. Can you break that down simply for us?
Sure. Think of it like this. De jure annexation means annexation by law. It's when the occupying power makes an official declaration, passes a law, saying this territory is now part of our country. Formal sovereignty is claimed. De facto annexation means annexation in fact or in practice. This is where, even without a formal declaration, the occupying power takes actions on the ground that effectively achieve the same result: permanent control, integration, treating the territory as its own.
So different methods, same goal.
That's essentially what the sources say the court found. It noted this distinction is sometimes made, but ultimately concluded that both types share the same underlying objective: asserting permanent sovereignty and control over the occupied land. And the court then concluded, as cited directly in the sources, that certain specific Israeli policies and practices do amount to annexation, specifically annexation of large parts of the occupied territory.
Which policies are highlighted?
They point to things like the decision back in December 2022 to create a new ministerial post within Israel's Ministry of Defense, and giving that minister governing powers over civilian aspects of the West Bank, like land administration, planning, settlement approvals. The explicit goal stated at the time was to speed up settlement construction. The sources state the court specifically noted Israel transferring these powers to a civilian administration within the Ministry of Defense in 2023. The court viewed this as being consistent with the Israeli government's own guiding principles from 2022, which openly talked about applying sovereignty over the West Bank.
So the court saw this move to civilian administration for these key powers and the stated political goals behind it as clear evidence of an intent towards permanent control, even without Israel making a formal declaration saying we annex the West Bank.
Exactly. The sources indicate the court viewed these policies and practices, the transfer of powers, the political goals explicitly stated as being, quote, designed to remain in place indefinitely and to create irreversible effects on the ground, end quote. And because of this perceived permanent intent and these irreversible actions, the court found they amount to the annexation of large parts of the occupied Palestinian territory, end quote. The court's perspective, as presented in the sources, is that this whole effort to gain permanent sovereignty over occupied territory, demonstrated through practices in East Jerusalem and the West Bank, fundamentally violates those core international law principles we discussed earlier, the prohibition on using force and the non-acquisition of territory by force. The sources also connect this to Article 47 of the Fourth Geneva Convention, which says that people living in occupied territory can't lose the protections they get under the convention just because of changes imposed by the occupier, including any annexation of the whole or part of the occupied territory.
Now, here's where it gets really concrete and, frankly, quite striking. The sources highlight a very specific and recent decision made in May 2025.
Yes, this is a decision the sources describe as truly unprecedented. It was made by Israel's Ministerial Committee on National Security Affairs, essentially their top security cabinet, in May 2025. And the decision was to initiate a process called land title settlement across the West Bank. The sources state this decision effectively works to, quote, completing its annexation and entrenching Israel's unlawful presence. It's presented as a major step in solidifying control.
And what did the Israeli Minister Smotrich, as quoted in the sources, say was the purpose of launching this land title settlement process?
The sources quote Minister Smotrich, quite directly explaining the goal. He stated, for the first time, Israel assumes responsibility over the territory as a permanent sovereign. That's a very direct claim. He added that this process will provide a land reserve for the expansion of settlements. It will prevent the takeover of the hinterland by the Palestinian Authority, and this is quite stark. It will facilitate an additional 1 million settlers in order to eliminate the Palestinian terror state. The sources also provide context, noting he had previously talked about land registration back in 2017 as being essential to his vision for massively expanding settlements to solve Israel's own housing needs.
Wow. That language quoted in the source is incredibly explicit about permanent sovereignty, expanding settlements, and the political goals. How would this land title settlement process actually work on the ground, based on the details in the sources? And what are the main challenges it presents for Palestinians?
Based on the sources, the process works something like this. Anyone claiming ownership of a piece of land has a limited time window to submit their claim and provide formal proof of ownership. Then, the Israeli Land Authority reviews these claims, decides who the owner is according to their criteria, and officially records that title in the land registry. Once land is registered and the short period for objections is over, the sources note that challenging that outcome later on becomes extremely limited under Israeli law. It essentially makes those land titles permanent and very difficult, if not impossible, to overturn legally within that system.
And the challenges for Palestinians?
The sources present this as a huge problem for Palestinians on two main levels. First, for individual property rights. Many Palestinians face enormous difficulty getting the specific kind of original ownership documents required by this Israeli process. These documents might be very old, possibly located in archives in Turkey or Jordan from the Ottoman or Jordanian periods, or simply lost over decades of conflict, occupation, and displacement. Getting them is described as complicated, expensive, and often hampered by unresponsive authorities. Plus, a lot of Palestinian land has been owned by families for generations, sometimes over a century, without ever going through formal registration. Proving continuous ownership across that time, especially when a single property might now have dozens of different heirs who all need to collectively prove their claim, becomes incredibly difficult legally.
So a huge burden of proof issue. What's the second challenge?
The second challenge, according to the sources, is that this entire process fundamentally undermines the Palestinian Authority itself. They argue these legislative changes imposed by Israel weaken the Palestinian Land Authority and related bodies that are trying to consolidate and protect Palestinian property rights and manage public land, particularly in Area C of the West Bank, where Israel currently retains full civil and security control. The sources actually cite the UN Secretary General's report from 2023 on this. That report stated that this kind of settlement of land titles is an irreversible act of sovereignty by a permanent regime. The UNSG found it subverts the principle that occupation is inherently temporary and significantly increases the risk of illegal appropriation of property and a forcible transfer of the Palestinian population. And that same report warned, as we touched on earlier, that transferring administrative powers over land and planning from the military to Israeli civilian bodies could facilitate annexation, which is a clear violation of international law.
So this May 2025 land title settlement decision, with its explicit stated goals and the practical impact described, is presented in the sources as a really concrete example of the annexation and the intent for permanent control that the ICJ's findings were concerned about.
That seems to be the connection the sources are drawing, yes.
The sources also mention Israel's planning policy in the occupied territory as another area that ICJ examined. What did they say about that?
Yes. The ICJ, as cited in the sources, looked at Israel's planning and zoning policies in the occupied territory, particularly as implemented through various legislative amendments over the years. The court found that these policies cannot be justified by reasonable criteria or any legitimate public purpose allowed under occupation law. Specifically, the court pointed to the widespread practice of refusing building permits to Palestinians, while simultaneously facilitating settlement construction. And the consequence of refusing permits is often the demolition of Palestinian homes, farms, schools, clinics, any structure built without that unobtainable permit. The court concluded that this happens on a sweeping scale, serves no legitimate aim under occupation law, and effectively treats Palestinians differently from Israeli settlers without any valid justification. Therefore, the court deemed Israel's planning policy to be a serious breach of international law, violating both humanitarian law and human rights law, and it stated this breach must be reversed and properly redressed.
And the sources link this back to the obligations of other states.
They do. They suggest that the obligation on other states not to recognize or assist unlawful acts should logically require a fundamental shift in how those states approach issues related to Area C and the rest of the occupied territory, given these findings on planning and demolition policies.
Okay. Shifting focus now from these longer-term issues of land control, annexation, and planning, the sources also address more immediate human needs, specifically the protection of humanitarian relief efforts and aid workers operating in the occupied territory.
Right. And this is clearly a pressing issue. The sources refer to another UN General Assembly resolution, this one adopted in December 2024, Resolution 79232. This resolution actually asked the International Court of Justice for another advisory opinion.
Another one on what?
This time, specifically about Israel's legal obligations concerning the presence and activities of the United Nations, other international organizations, and humanitarian aid groups working in the occupied Palestinian territory. The sources note the resolution requested this new opinion be delivered on a priority basis and with the utmost urgency, reflecting the dire situation, particularly in Gaza at the time. According to the sources, this December 2024 resolution explicitly reinforced key points from the ICJ's July 2024 opinion, things like confirming the occupation's illegality, reaffirming the Palestinian right to self-determination, and restating Israel's obligation not to obstruct that right. But importantly, the sources say this resolution makes a direct link. It connects actions that obstruct essential services and humanitarian aid to the civilian population, not just to the immediate suffering caused, but also to contributing to further forced displacement of people.
Connecting aid denial to displacement.
Exactly. And the sources highlight that the July 2024 ICJ opinion had already found that causing forced displacement violates the prohibition on forcible transfer found in Article 49 of the Fourth Geneva Convention. So there's a clear legal thread being drawn here between hindering aid and committing a serious violation of IHL.
Before we get into aid specifically, what are the basic duties of an occupying power like Israel when it comes to public order and safety for the civilian population in the territory it occupies? What does international law, as cited in the sources, require?
The sources point to Article 43 of the 1907 Hague Regulations as the foundational rule here. They call it the cornerstone of the constitution of belligerent occupation. This article requires the occupying power, Israel in this case, to take all the measures in its power to restore and ensure, as far as possible, public order and safety. This means the occupying power has the responsibility for temporarily administering the territory and maintaining basic civil life. The sources explain this includes ensuring public welfare, things like making sure people have access to housing, healthcare, education, food, water. This duty is limited only by the requirement to respect the existing local laws, unless absolutely prevented. The sources also mention another Hague regulation, Article 48, which says the occupying power generally has to use local taxes to pay for the administration of the territory. But if those aren't enough, it has to use its own funds to maintain these essential public services.
So the primary responsibility is on the occupier to ensure basic needs are met.
Yes. The sources emphasize that while the occupying power has the main job of meeting the basic needs of the local population, ideally using resources available within the occupied territory itself, if those needs cannot be adequately met that way, they then have a secondary duty to bring in necessary supplies and assistance themselves. And then comes the crucial part for external aid. If the population still remains inadequately supplied even after the occupier's efforts, then the occupying power must, the word used is must, agree to relief schemes and shall facilitate them by all means at its disposal.
So it's not just a choice, it's a legal requirement to allow external humanitarian aid in that situation.
That's exactly what the sources state, based on interpretations of the Fourth Geneva Convention, particularly Articles 59 and 60. International law, in its commentaries, as cited, explain that unlike other parties in an armed conflict who might have more discretion, an occupying power is legally obliged to consent to impartial humanitarian aid operations aimed at helping the inadequately supplied occupied population. They are allowed to make practical arrangements, inspect consignments to ensure they are indeed relief goods, and control the distribution to make sure it gets to the intended beneficiaries. But these controls cannot undermine or infringe upon the fundamental obligation to ensure the aid passes rapidly and unimpeded. The sources note the ICJ has specifically affirmed this principle regarding the situation in Gaza.
What kind of restrictions aren't allowed then?
The sources are clear. Arbitrary, capricious, or unlawfully denied restrictions are forbidden. Any restriction imposed must be temporary, exceptional, justified by legitimate grounds like imperative military necessity or genuine security concerns directly related to the aid operation, and must always serve the population's interests, not hinder them. Things like deliberately slowing down inspections, excessive bureaucracy, diverting aid, or confiscating it are strictly prohibited.
And the sources also raised the disturbing possibility that denying humanitarian access could actually constitute an international crime.
They do. It's a very serious point. The sources state that if an occupying power deliberately withholds consent for essential humanitarian relief when the civilian population is clearly inadequately supplied, and does so with the intention of causing, contributing to, or perpetuating starvation, this violates the explicit prohibition in international humanitarian law against using starvation of civilians as a method of warfare. Such actions, they state, make the state responsible for gross and systemic breaches of IHL.
And for individuals involved.
Yes. The sources discuss individual criminal responsibility here, too. If someone intentionally acts to willfully impede the delivery of relief supplies essential for survival, or deliberately deprive civilians of objects indispensable to their survival, like food, water, medicine, with the specific intent to starve civilians as a method of warfare, this is explicitly codified as a war crime under Article 8 of the Rome Statute of the International Criminal Court. And the sources add another layer. If this deliberate obstruction of aid is done as part of a wider attack against the civilian population and with the specific intent to inflict conditions of life calculated to bring about the physical destruction of a protected group, in whole or in part, it could potentially constitute an underlying act contributing to the crime of genocide under Article 6C of the Rome Statute.
That really underscores the gravity of denying essential aid. Based on these findings about humanitarian access obligations and potential crimes, what concrete actions do the sources recommend other countries should take?
The sources list several concrete steps countries should consider based on these legal findings. These include publicly reaffirming the fundamental protections for civilians in occupied territory, including their right to access essential services without arbitrary interference, specifically stating that starving civilians as a method of warfare is prohibited and must be prevented. They should call on Israel, as the occupying power to immediately rescind any arbitrary measures that deny or impede humanitarian access. They should affirm clearly that relief operations must be allowed to proceed impartially and without arbitrary interference or delay. And crucially, they should take effective measures to ensure that any UN-mandated investigative bodies like commissions of inquiry or fact-finding missions have full and unimpeded access to the occupied territory to investigate allegations of wrongful acts and international crimes, including looking into the potential use of starvation as a method of warfare.
Okay. Another significant prohibition that the sources discuss in detail is the prohibition on the transfer of populations. This seems central to many of the issues.
Absolutely. It's a key point the sources highlight, drawing again from the ICJ's findings, both in the earlier Israeli practice's opinion and reaffirmed more recently. The court found that Israel actively facilitates and encourages the transfer of parts of its own civilian population into settlements established in the occupied West Bank, including East Jerusalem. The sources state the court concluded this directly breaches the 6th paragraph of Article 49 of the 4th Geneva Convention. That article is very explicit. The occupying power shall not deport or transfer parts of its own civilian population into the territory it occupies.
Why was that rule put in the Geneva Conventions in the first place? Do the sources explain the rationale?
Yes. They cite the official 1958 ICRC commentary on Article 49. That commentary explains the historical context. This provision was specifically intended to prevent the kind of practices witnessed during World War II, where occupying powers systematically moved their own citizens into occupied territories. This was done, the commentary notes, often for political and racial reasons, or straightforwardly, in order to colonize those territories. The drafters recognized that such population transfers inevitably worsened the economic situation of the native population and endangered their separate existence as a race. The sources connect this directly to settlement construction, pointing out that the associated infrastructure is often designed to integrate the settlements into Israel proper, reinforcing the idea of transferring population for colonization purposes.
So that's about moving the occupier's population in. What about moving the occupied population out?
Right. The sources also discuss the other side of Article 49. The prohibition on the forcible transfer or deportation of the protected population, meaning the Palestinians living under occupation. This is covered in the first paragraph of Article 49, which prohibits individual or mass forcible transfers, as well as deportations of protected persons from occupied territory, regardless of their motive. The sources state the court interprets this very broadly, seeing it as protecting the occupied population against any involuntary transfer out of their homes or areas.
And similar to how we discussed forcible in the context of aid denial possibly leading to displacement, does forcible transfer here necessarily mean physical force, like loading people onto trucks?
No, not necessarily. The sources clarify this point, citing legal interpretations. A transfer can be deemed forcible, and therefore illegal under Article 49, even if no direct physical force is applied. This happens if the circumstances created by the occupying power leave people with effectively no choice but to leave. The sources explain how actions like forced evictions, large-scale house demolitions, often for lack of permits that are near impossible to obtain, as we discussed, severe restrictions on residency rights, freedom of movement restrictions that make daily life untenable, destruction of livelihoods, and settler violence can combine to create a coercive environment. This coercive environment, the sources argue, can leave Palestinians, especially those living in vulnerable areas like Area C of the West Bank or parts of East Jerusalem, with little practical alternative but to abandon their homes, lands, and communities.
So creating conditions that compel people to leave is legally viewed as forcible transfer.
That's the argument presented in the sources, yes. They also argue that the nature of Israel's actions in these situations, including, often, the subsequent confiscation of the land, after demolition specifically for reallocation to settlements, clearly indicates these measures are not intended to be temporary. Therefore, they cannot be justified under the very narrow exceptions in IHL that might permit temporary evacuations for the population's own security or imperative military reasons. Based on all this, the sources conclude that other states should clearly affirm that Israel's policies and practices violate both the prohibition on forcibly transferring the protected Palestinian population out of their areas and the prohibition on transferring its own Israeli population in to colonize the territory, actions which endanger the fundamental rights of the Palestinian people, including their right to self-determination.
And this ties back directly to the concerns raised earlier about potential deportation, particularly the proposals regarding the population of Gaza.
It absolutely does. The sources explicitly mentioned the deportation directive that was reportedly outlined in an Israeli Ministry of Intelligence white paper back in October 2023, very shortly after the October 7th attacks. This paper, as described in the sources, proposed the mass, permanent deportation of the entire civilian population of the Gaza Strip into Egypt's Sinai Desert. The sources characterize this proposal, if acted upon, as potentially involving multiple grave breaches of international law. They identify three potential criminal elements. First, the forcible transfer of the population within Gaza, forcing them south, as a prelude. Second, the actual deportation to Egypt, which would constitute a grave breach and permanently deny them their right to return home. And third, the potential international responsibility of any other states that might recognize, aid, or otherwise support such acts. The forces underscore the extreme seriousness of this by citing former ICJ President Nawaf Salam's concurring declaration in the July 2024 opinion. He stated, as we mentioned regarding aggression, that annexation by force constitutes a crime of aggression, and he explicitly urged states to use the ICJ's findings to prevent and punish the perpetrators of such acts.
Okay. One final major area the sources touch upon is the legal standards that apply to an occupying power's use of force within the occupied territory itself. How should force be used in that context?
Yes, this is crucial. The sources explain that once a territory is effectively occupied and brought under the control of the occupying power, meaning the previous government isn't functioning there, and the occupier has established its authority and is maintaining some level of public order, the legal framework governing the use of force primarily shifts. It moves away from the rules governing the actual conduct of hostilities during active fighting and shifts primarily towards a law enforcement model.
A law enforcement model, like
Yeah.
police have. Essentially, yes. This model, rooted in the occupying power's duty under Hague Regulations Article 43 to ensure public order and safety, applies when the occupier has a relatively secure hold and is acting more like a police force maintaining day-to-day order rather than fighting an active battle. Under this law enforcement model, the rules for using force, especially lethal force, are much stricter. International human rights law becomes the primary benchmark, prohibiting the arbitrary deprivation of life. Lethal force is permissible only under very narrow, specific circumstances, when it is strictly unavoidable to protect human life from an imminent threat, and only when less extreme measures, like warnings, non-lethal force, are clearly insufficient to achieve that objective. The sources state this use of force must rigorously adhere to the principles of necessity, proportionality, and precaution, guided by standards like the UN Basic Principles on the Use of Force in Firearms by law enforcement officials. What happens if there are incidents of violence or disturbances within the occupied territory? Does it automatically flip back to the looser conduct of hostilities rules?
Not necessarily, and this is an important distinction that sources make. They differentiate between situations of internal disturbances and tensions, sometimes abbreviated as IDT, and full-blown armed conflict or hostilities. IDT situations involve lower levels of violence, things like riots, sporadic attacks, isolated acts of violence. They haven't reached the intensity or organization of sustained armed conflict. In these IDT situations occurring within occupied territory, the occupying power can use force to restore order, but it must still primarily adhere to the stricter law enforcement standards and respect international human rights law. The sources emphasize that core human rights protections remain applicable and cannot be suspended during such disturbances.
Okay, so law enforcement standards are the default in occupied territory. When do the rules of hostilities potentially apply?
The rules governing the conduct of hostilities might apply in specific circumstances if a situation escalates to the level of actual armed conflict within the occupied territory. This requires a higher threshold of intensity and organization of violence. Even then, the sources stress it's about individual conduct. Civilians living in occupied territory are, by definition, protected persons under IHL. They only lose that protection against direct attack temporarily, and only if and for such time as they take a direct part in hostilities.
What constitutes direct participation in hostilities? That sounds like a key concept.
It is, and the sources emphasize it must be interpreted very strictly. It refers to specific, concrete acts carried out by an individual that meet three cumulative criteria. 1. The act must be likely to adversely affect the military operations or military capacity of a party to the conflict, or likely to inflict death, injury, or destruction on persons or objects protected against direct attack. 2. There must be a direct causal link between the act and the harm likely to result. 3. The act must be specifically designed to directly cause the required threshold of harm in support of one party to the conflict and to the detriment of another.
So it has to be a specific, harmful act directly linked to the conflict.
Exactly. It's not about someone's general support for one side or their political views. It's about specific actions. The sources strongly emphasize that this concept must be interpreted narrowly to maintain the crucial distinction in IHL between civilians, who have protected status, and combatants, who can be targeted. Therefore, civilians who directly participate in hostilities lose their protection from direct attack only for the specific duration of each distinct act of participation. They don't become legitimate targets around the clock just because they participated once. And even when targeting someone who is directly participating, the fundamental principles of warfare still apply. Military necessity, the attack must be necessary and not otherwise prohibited, like causing disproportionate harm or forced transfer. Distinction, attackers must still do everything feasible to distinguish the person participating from other civilians, and proportionality. Plus, the principle of precaution is paramount. Forces must take constant care to spare civilians, always presume someone is a civilian in case of doubt, and verify targets.
We have certainly covered a significant amount of complex legal ground today, based entirely on the sources you shared with us. We've gone from the core legal finding by the ICJ back in July 2024 that the Israeli occupation itself, under its current prolonged and acquisitive conditions, is unlawful, all the way through to the detailed implications this has. Implications for other countries and their obligations under international law, what full reparation actually means, and the challenges with existing mechanisms like UNRWA, the legal perspective on specific actions like the May 2025 land registration decision, potentially amounting to annexation.
The clear obligations regarding humanitarian access, including the potential for aid denial itself to constitute an international crime, the strict prohibitions on transferring populations both into and out of the occupied territory, and finally, the specific legal standards governing the use of force in an occupation context, shifting primarily to a law enforcement model.
It's really clear from these sources that established international law provides quite extensive, detailed frameworks for dealing with situations of military occupation. It spells out responsibilities for the occupying power, duties for other states, and potential pathways for reparations and individual accountability.
Exactly. And the ICJ's recent advisory opinions, along with related UN actions, as they're presented in these documents you provided, don't just restate these general principles. They apply them very specifically to articulate legal conclusions about the current situation in the occupied Palestinian territory, based on the facts and evidence as assessed by these international bodies. They really lay out how these key international legal institutions view the situation, what they see as the resulting legal duties for Israel and for all other states, and they outline mechanisms, however challenging, for trying to achieve accountability and make amends for the harm caused.
So when you boil it all down, what does this detailed legal analysis from the sources ultimately mean? It paints a picture where these international legal bodies interpret the ongoing situation through the lens of established international law, and they see very clear legal duties arising from that interpretation, duties that fall not just on the occupying power, but arguably on the entire international community.
Which leads us to a final important question, really something for you, the listener, to consider as you continue to follow developments and engage with information on this complex topic. Given the sheer level of detail in these legal findings we've discussed today, the strong emphasis placed on the obligations of all states to ensure respect for international humanitarian law, and the specific mechanisms outlined for reparations and accountability. How might these explicit legal interpretations, as presented in the sources, practically influence what happens next? How might they shape diplomatic discussions, the actual policy decisions made by individual countries around the world, or the future actions taken by international organizations like the UN in the coming months and years? Especially considering that gap, the sources themselves note between the clarity of the legal findings and the current reality of compliance and enforcement.
That's definitely a lot to think about. Thank you for bringing these sources to our attention and allowing us to take this deep dive into them with you today.